Welcome, everyone, to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This series is run by the University of New Mexico's Division of Forensic Behavioral Sciences in our Department of Psychiatry and Behavioral Sciences, along with support of the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, you can enter those in the Q&A box. Enter those anytime you feel comfortable, but do know that we hold questions until the end, and oftentimes it's not possible for us to get through all of them. In terms of continuing education credits, if you are pursuing continuing medical education credits, there's a sign-in sheet that's posted in the chat box now that you can complete. For those of you that are pursuing APA continuing education credits, there will be a link in the chat box for a survey that you will complete to get your certificate. That will be near the end of the presentation. You'll keep your eye on the chat box in the last 5 to 10 minutes at the top of the hour. Make sure you open that link before the webinar closes or otherwise copy it, bookmark it so that you have that link for the survey after the webinar is done. And make sure once you complete the survey that you save your own copy of the certificate for your CEU credits. If you've missed our most recent talk in the series, Dr. Michael Chavitz's discussion of reviewing records and its impact on clinical judgment is now available on our YouTube channel. The recording for this week's talk should also be available on our YouTube channel sometime later this week, and a version of the PowerPoint slides for those that have registered for the series should be available later this week to them as well. As a heads up, next week we have a panel of Doctors Lisa Kahn, Crystalline Tussey, and Beth Arredondo discussing issues of aging and cognition relevant to forensic evaluation. But circling back to this week, I'm very excited and honored to introduce you to today's speaker, who'll be discussing principles of forensic report writing. This week we have joining with us Dr. Randy Otto. Dr. Randy Otto previously served on the faculties of the University of South Florida and Nova Southeastern University, and last May he joined us in the School of Medicine at University of New Mexico as our chief of the Division of Forensic Behavioral Sciences in our Department of Psychiatry and Behavioral Sciences. We, and I specifically, have been absolutely thrilled working with Dr. Otto and him sharing his wisdom and his support and efforts with us so far over this year. His research and writing has focused on forensic psychological assessment. He's authored or edited 7 books devoted to forensic psychological evaluation, expert testimony and report writing, ethics in forensic psychological practice, assessment of trial competence, violence risk assessment, and Florida mental health law. Dr. Otto has served as a president of the American Psychology Law Society, the American Board of Forensic Psychology, and the Board of Trustees of the American Board of Professional Psychology. He's also a fellow of Division 41 of the American Psychological Association and has received a number of awards for his work from the American Academy of Forensic Psychology, the American Psychology Law Society, Society for Personality Assessment, New York State Psychological Association, University of Nebraska, and the University of California, San Francisco. He currently also serves as the executive director of the American Board of Forensic Psychology. So, Dr. Otto, Randy, on behalf of your home here at the University of New Mexico, thank you so much for joining this series and sharing all of your expertise with this wide audience for us today. I'll go ahead and toss it over to you.
Yeah, thank you, Anthony. I'm glad to be able to do this today. I've certainly participated in this series a number of times previously, but this is my first time participating as a member of the host institution, the University of New Mexico. Happy to be here. You can see I've completely adapted. I'm wearing Mountain Man shirts and things like that. I'm also wearing some climbing shoes that you won't get a look at, but I think I'm doing well in terms of making the transition to the American Southwest. Let's get going. You already addressed the CE issues. I'll point out that I don't have any financial arrangement related to the content of this activity. And anything I say here today is my view, my perspective, and my opinion for sure, and don't reflect in any way the views, policies, or positions of the University of New Mexico. I think I may be getting a signal from our technical advisor. Do you have anything for us to address, Alex?
Thanks, Randy. It just seems as though your slides aren't going forward. It's still
Oh,
showing the title slide. So I just
okay.
want to check in with you about that. You might just need to reshare real quick.
I'm going to stop the share and
Perfect.
then come back in, I think. So let me see if I can do that. Ooh, sorry. I really, uh, uh, hmm. Uh, are they moving now?
They are not. So you may just want to close the PowerPoint and then reopen the PowerPoint.
And I'll go ahead and have it with me. If we need a backup, I can also advance the slides. So,
About today. Got a few more disclosures to cover, my own, cover some preliminary matters. Why do we write reports? Get into the general principles of forensic report writing. Then we'll save some time for discussion. At the very end of this PowerPoint file are a number of references that I recommend you consider. I'll be discussing some of them during the course of the presentation, and there's some others there listed for the interested viewer. Among the references I'll be presenting, there are two for which I receive royalties. If they're purchased, they're highlighted in green to reflect my financial benefit if you end up buying them. I'll say I've never written the perfect report and continue to aspire to write the perfect report, but never let perfection be the enemy of good. If I suggest something today about report writing that is contrary either to the law of your jurisdiction or the requirements of your employer, don't do it. But maybe ask yourself why it can't be done the way I'm suggesting. Okay. Some preliminary matters. I'll say this. I consider when we write reports or when we testify, I consider that efforts to persuade a decision maker, a judge, a jury, or a non-decision maker, an attorney. I think I'm all for persuading people to adopt our opinions that we may come to when we're involved in cases. I'm all behind that. And I think writing good reports is one way to persuade others, at least report readers. I will add that in order to persuade decision makers or attorneys who don't make decisions, legal decisions at least, competent evaluation is probably necessary, but not sufficient. You can do a competent evaluation, and if you can't summarize it, either in written form by way of a report or verbally by way of testimony, I don't think you're persuading anyone. Effective communication, either by way of writing a report or less frequently testifying, effective communication is necessary but not sufficient for persuading a decision maker. I don't care how good a writer you are. I don't care how good an orator you are. If you don't carry out the appropriate evaluation, again, hopefully you're not persuading anyone. I'll say that persuading the decision maker likely requires both competent evaluation and effective communication, either by way of report writing or testimony. But we're only going to concern ourselves during this hour with the latter, specifically report writing. I want to start by asking, why is it that we do write reports? For a number of reasons. One is because the law requires it in many cases. Now, I'm not going to go through an exhaustive discussion of where you can find laws that require those who carry out forensic examinations to write reports, but I'll just give you one commonly encountered example here. Federal Rule of Civil Procedure. Many of you who do civil work in federal court, this will be familiar to you, but the rules of civil procedure direct that failure to deliver a report may play out so that the examiner may not testify at trial. So if you conduct an evaluation in federal proceedings in a civil context and you don't write a report that meets the many requirements of what a report must involve and include, you may well be prohibited from testifying in front of the judge or worse, the jury. Not all jurisdictions and not all contexts do require that the proffered expert write a report, but in many cases that is required. And obviously, we're all going to be familiar of the laws and rules of the jurisdictions in which we practice. Another reason we write reports is because it's the most efficient way of communicating a whole bunch of stuff. Why you're involved in a case, what your role was, what you were asked to do, the data sources you both accessed and didn't access, the data you ended up gathering yourself, data that were provided for you, your opinions, and your reasoning as well. Nothing comes close to presenting all of this information as efficiently as a report does. And anyone who's written a report knows that writing a report is the most effective and efficient way of reasoning through all the data, some of which can be conflicting. It's a great way to identify and reconcile inconsistencies in data that was run by you, opinions that you're forming, and it's a great way of identifying strengths and weaknesses, both of your technique and the opinions that you form. You can, if you're directed by an attorney not to write a report, but just go in and testify, my take is you can claim all day long that without the benefit of writing a report, you're going to reason through the pros and the cons, the limitations of your work, the strengths of your work, you're going to manage and make sense of all those inconsistencies. You can say you're going to do all that in your head. You're not going to do it near as effectively, in my opinion, as if you actually put pen to paper or put your fingers on the keyboard to write the report electronically. And of course, writing a report requires you to commit to opinions and commit to reasoning, which is, I think the reality is that that's one reason that attorneys would prefer that in some cases, at least, experts who've conducted examinations don't write reports. They don't want them committing. They don't want them efficiently communicating to opposing counsel all they did, how they were involved, the information they had access to, the information they didn't have access to, their reasoning and their opinions. So with all of that, let's talk about general principles of forensic report writing, or just general principles, so we're not going to get into the weeds on this, but keep it a more general level. Throughout this slide presentation, I have a principle. I have the principles laid out in red, and then we'll talk about meeting them and how we sort of accomplish some of those goals in black, but we'll remind you of the general principles with a red heading. Principle, the entirety of the examiner's examination effort is documented. And what I would say is that a principle is that included in every report summarizing a forensic evaluation is language referencing how the examiner was involved in the case, who were you hired by, what was the assignment, what did the retaining attorney or the appointing court or judge direct or request that you do, reference to key data the examiner both did and did not have. And the reason I mention the did have is sort of obvious on its face, but I think examiners should reference when they are missing data, because one, if it is the data that is typically considered or accessed when carrying out a particular kind of evaluation, you want the reader on notice to that. And if you didn't have that data, despite your good efforts to request that data or to access that data, I think you should get credit for it up front. You should affirmatively disclose it. I made numerous efforts to meet with and interview plaintiff's supervisor, but the plaintiff's supervisor was not made available or whatever else, because if you do get hit on cross-examination with, well, Dr. Otto, did you consider that the plaintiff's work supervisor could have some helpful information? It's very nice to be able to say, as I referenced in my report, I made numerous efforts to make contact with plaintiff's supervisor, yet he was not made available to me, or he didn't respond to my efforts, or whatever it was. And you're in a much better situation if you can say that, referencing the affirmative attempts you made, than to simply say that without the benefit of having mentioned that in the report. I think you also, somewhere in the report, should be a discussion of the examination process, including affirmative disclosure of any deviations from standard practice, including, for example, maybe missing data sources that you typically do rely on in this kind of evaluation. Obviously, the examiner's opinions, the examiner's reasoning, its strengths and its weaknesses as well. Another principle, complicated matters are uncomplicated and the writer makes sense of the data for the reader. This is really the primary purpose of the report, as well as one's testimony. And the way I encourage people to think about this is think about Rule of Evidence 702. Look at the federal rules of evidence. Many states, of course, their own state rules of evidence sort of parallel the federal rules of evidence. Think about that the reason that the examiner is brought into a case is because there's some kind of legal dispute. There's a complicated matter that's part of this legal dispute, a complicated matter involving psychological or psychiatric, cognitive, emotional, behavioral functioning that's considered beyond the understanding of the legal decision maker, the judge or jury. And it's thought that the examiner, who has specialized knowledge, expertise as a function of training, education, and experience, can be helpful to them, can provide the legal decision maker with information that it would not otherwise have, and presumably can make a more informed and presumably more accurate judgment. So one of the reasons experts get involved is to uncomplicate or discomplicate complicated matters for laypersons who don't have expertise in ballistics or postmortem examinations or psychological impairment or whatever else the issue is in front of the judge or jury. And what I say is the goal of the goal of the experts' efforts is to provide a report, have whoever's reading the report or listening to your testimony finish the report, understand all you did, learn of all the facts you considered, learn of the opinions you formed and your underlying reasoning, and then say, you know what? This stuff is really not that complicated. You have done the excellent job, is if that's how they come away, because you have essentially uncomplicated or discomplicated the complicated stuff they brought you in to help them understand and explain. This is a quote from a famous anthropologist, Margaret Mead, and she's talking about functioning in the ivory tower. But this is what she wrote: if one cannot state a matter clearly enough so that even an intelligent 12-year-old can understand it, one should remain within the cloistered walls of the university until one gets a better grasp of one's subject matter. Now, again, I acknowledge that Professor Mead was not talking about expert testimony, but I think the same applies, that if you can't talk about mental disorder or what it takes to understand and participate in the legal process, or how people can be injured by sexual harassment or sexual assault in the workplace, if you can't talk about how neurocognitive disorders limit your ability to understand and execute a will or a trust, you really have no place being in the courtroom and trying to help other people, that is, legal decision makers, understand these complicated matters. If you can talk about this in a way so that motivated, reasonably intelligent people can understand what you're saying. Well, how do we go about discomplicating? And one of my pet peeves, of course, is the use of jargon and how it actually is not helpful to uncomplicating or discomplicating. So general principle, right? Avoiding or explaining jargon, either when we write our reports or when we testify, right? So we'll use plain English. For example, use is better than verbalized, used is better than utilized, said is better than verbalized, and walked is better than ambulated. A few years ago, myself, Rick Demir, and Mark Boccaccini wrote a book on report writing and testifying, and Rick Demir wrote in one of his sections of the book that think about pirates, right? Pirates never made anyone ambulate the plank, but they did make them walk the plank. And when we're writing or talking to laypersons, walk is just fine. No need to use 25-cent words when nickel words will do. And of course, if we must use technical terms and jargon, we define or explain them for the reader. Again, explain complicated terms and concepts in common sense language, maybe even contemplating the potential value of using examples in our writing or our testimony. Use examples that might be more familiar to the reader. Many, many years ago, well-known forensic psychiatrist Park Dietz was testifying in the Jeffrey Dahmer trial, right? Dahmer, a young man accused of drugging, kidnapping, killing, and eating a number of young men in the Milwaukee area. Everyone agreed that Jeffrey Dahmer had problems and was impaired, but there was a dispute as to whether the level of his impairments rose to the height that he should not be held criminally responsible for these actions. Dr. Dietz was retained by the prosecution in that case, and he talked about some of the unusual beliefs Dahmer had and tried to find parallels that members of the jury might be more familiar with, right? And his point was, simply because you have an unusual or an uncommon belief, it doesn't mean that you're mentally ill, right? And I think he made reference, for example, to people who believe that crystals have healing powers. There's a subset of people who believe that we've never made it to the moon. that in and of itself doesn't mean that they have a mental illness. Now, Dietz, of course, did acknowledge some mental disorder on Dahmer's part, but his point was that some of these beliefs in and of themselves do not reflect mental disorder. I was involved in a case a few years ago involving a Vietnam veteran, and one of the claims he made was that John McCain, the war hero, colluded with the Viet Cong to shoot down U.S. fighter jets. John McCain colluded with the Viet Cong to shoot down U.S. fighter jets. Now, pretty unusual belief. And the defense was very much invested in suggesting this reflected that the defendant, the Vietnam veteran, was mentally ill. I pointed out that, look, we have people who believe crystals have healing powers. There's people who believe we never went to the moon, and the world is flat. And we don't consider them, just because of that, to be mentally ill. So taking a complicated concept, the distinction between delusions and uncommon beliefs, and maybe trying to identify examples or cite examples that are more familiar with the audience that you're trying to persuade. Here's some of my favorite jargon, and we'll talk about the jargon hotspots a little later. But I've seen all of this. A few years ago, I was spending a lot of time with immigration court judges, and I was trying to make this point. If the expert that you hire or appoint as a judge uses words that you don't understand, or uses concepts you don't understand, doesn't write about them in a way that you understand, doesn't explain them, doesn't discomplicate in their reports or otherwise, they're not doing their job. And it was very interesting when I sort of cited that for them. They came up with a number of examples. For example, Dr. Otto, why do these mental health professionals in their report refer to the names and dosages of medications as if any of that means anything to me as an immigration court judge? Or better yet, Dr. Otto, kind of showing you how long ago this was. Dr. Otto, I have this question. A diagnosis I often see in these mental health professionals' report is psychotic disorder NOS. Psychotic disorder NOS, right? Now, we don't have not otherwise specified anymore, but just think about it. This expert was not spending enough time thinking, well, first of all, they're going to read NOS as NOS. They're not going to understand that it's shorthand for not otherwise specified, but that's not even enough, right? And if you're going to throw that diagnosis at the judge, you have to explain it in some reasonable way. Here's some other kinds of favorite jargon that I've seen. The last phrase there, ectomorphic male with idiosyncratic macho grooming, that was in a report that my colleague Rick Demir got when he was working at the Medical Center for Federal Prisoners in Springfield, Missouri. Demir and I are both old enough to know that there was a silly theory years ago that there was a relationship between personality and body type. We had ectomorphs, endomorphs, and mesomorphs. Ectomorphs were kind of skinny, endomorphs, little roly-poly, mesomorphs, well-built and muscular. So Demir was old enough to know that the guy that was about to come into his office was a skinny guy, but for the life of him, he couldn't figure out what the term idiosyncratic macho grooming referenced. Guy comes in his office, and what's his hairstyle? He's wearing a mohawk, right? Probably could have just written that, right? A mohawk, or his hair was shaved on the sides of his head with a strip of hair down the middle. How to avoid jargon? Pay particular attention to what we call the jargon hotspots: mental status examination, behavioral observations, diagnosis, test results, medical histories, and medications and other treatments. A few years ago, I was consulting with a neuropsychologist who was involved in a testamentary capacity case. And in his report, he had evaluated a person for whom testamentary capacity questions were the focus of the case. he had examined this individual around testamentary capacity issues, but in his report was summarizing the results of some neurologic testing. And he had a paragraph or two that he quoted verbatim from the neurologist's or the radiologist's report. And it was chock full of jargon, medical jargon, that I had some difficulty understanding as a reasonably experienced psychologist. And I told him, look, you put this in this format in the report that you're going to give to the attorneys and the judge in this bench trial matter, they're going to be clueless as to what any of this means. So don't fool yourself by thinking if I include this summary of the imaging work that the radiologist did, that'll be helpful or persuasive. I didn't disagree with letting the attorneys and the judge know about the results of that medical effort, but verbatim quoting was not the way to go there. Ask your spouse, who might be anything but a mental health professional, an engineer, or an accountant, to read your report and identify any problem spots. Another thing, the report writer writes the report in such a way to help the reader make sense of the data, okay? The reader may not know that some data are relevant and why they're relevant. If we're going to include it, we would only be including relevant data, hopefully. We'll talk about that later. And we would alert everyone to why it's relevant. The writer makes sense of and distills a voluminous amount of data for the reader and avoids the temptation to simply regurgitate all of the data on the pages of the report. I don't understand the logic of reviewing this many treatment records and simply dictating everything you're reading into the body of the report, that the examiner and report writer bear some responsibility from taking this much data and distilling it in and writing about it in a way that the key information is relayed to the reader of the report. One of my favorite quotes, it's been attributed to many people, but one of my favorite quotes, "I've made this letter longer than usual because I lacked the time to make it shorter," right? And this is oftentimes when I read these extended reports summarizing forensic examinations, that there was a lot of regurgitation going on. And the examiner maybe thought, it's going to take me less time and it's going to involve less effort to try to take all this information and use my time and my cognitive effort to distill it into a more reasonable number of words. That really takes effort. It's really easy to write extensive, very long forensic reports, but distilling them into something that is much more efficient requires more effort. And this is an unattributed quote. "If only experts were paid by the understanding they facilitate rather than the number of pages in their reports or the words they speak." Another way of helping the reader make sense of the data is distinguishing facts from inferences and opinions. So here's a hypothetical, right? The facts are that the police were called when a husband held a knife to his wife's throat and accused her of poisoning his food, and she stated that she wanted him jailed as a result of this assault. It's an inference that the husband presents a risk of harm to his wife given what occurred recently, and it's an opinion that he meets criteria for involuntary hospitalization. Okay, there's some facts that are really they can be disputed, but they're less likely to be disputed. There's the examiner's inference, and there's the examiner's opinion. Laying out the differences to the reader is helpful. The examiner provides the logic underlying assertions. So, for example, opinions that an examinee's reoffense risk about an examinee's reoffense risk are supported with specific reference to data. And the connection between data and opinions is made explicit in the report, the reasoning, right? When indicated, test results are presented as inferences or hypotheses rather than facts about the examinees, at least in many of the tests that psychologists administer, which, in many cases might be considered as being most valuable in terms of providing hypotheses for further investigation, measures of personality, many measures of psychopathology, etc. Another way of facilitating understanding by the reader is sharing reasoning either before or after the presentations of facts and opinions. So the reasoning is, right, symptoms of mental illness, paranoia, lack of insight into the disorder, leave the husband to believe he's at risk of harm, that's the paranoia, believe he's justified in defending himself because after all, he has this unshakable belief that people are trying to harm him. They also lead him to believe that he's not mentally ill, that's the lack of insight piece, and therefore he doesn't need treatment if he's not mentally ill. This results in a continuing risk of harm to his wife, and it also requires that he be exposed to some kind of intervention without consent and over objection if we're going to prevent harm. So sharing that reasoning, that sort of line of thinking with the reader is helpful to letting them know how you got to the opinion or the recommendation of treatment over objection or without consent or whatever else it is. In our book on psychological evaluations for the courts, we have this. A referral for forensic evaluation is not a license to inquire into any aspect of the examinee's life or behavior. Examiners should confine themselves to inquiries legitimately raised by the referral source and should restrict the substance of their reports accordingly. We'll talk more about this coming up. This quote from a forensic psychiatrist and colleagues, including in the report pejorative or embarrassing information that is irrelevant to the legal issue, may demonstrate a completeness of the interview, but it does so at the cost of the client's sick dignity. Those of you who know me know I'm very much of the school that we should refer to the people we examine as anything but our clients or our patients because of the potential to facilitate confusion. What does this mean? It means that when we write reports, we exclude data appropriately, right? So we typically address matters in the report that are limited to questions presented to us. We include in the report only data that are potentially relevant to the psycholegal issues, while data that are clearly irrelevant are excluded, okay? We also might even exclude relevant data if they might be considered legally or forensically inappropriate. I'll give you some examples of that coming up. I think some of the more experienced of you on the call in the training that do criminal work will be familiar with some examples. For the psychologists in the training, I'll point out that there's explicit direction that psychologists exclude irrelevant information from the reports. Technically, including irrelevant information in a report summarizing an evaluation is a violation of the ethics code. Here I have section 4.04 for your review. Also note that including irrelevant information increases the length of the report and the likelihood that the reader will skip to the end. It also has the potential, including irrelevant data, also has the potential to confuse the reader, because I think they're reasonably assuming that you wouldn't include irrelevant information in the report. So if it's in the report, it must be relevant somehow. And if we exclude relevant but problematic data, for example, self-incriminating statements made during the course of a competence evaluation, there are potential for complicating the examinee's legal status. So, for example, as I was suggesting earlier, many of you familiar with the general rule, and in fact, many states have prohibitions against including any self-incriminating statements that a criminal defendant might make during the course of a court-ordered competence evaluation in the body of the report summarizing that evaluation. What are some of the problems, including irrelevant data? Beyond that, there's the potential to embarrass the examinee or facilitate prejudice against the examinee. Sometimes in many forensic examinations, the person's sexual history, sexual experience, sexual orientation, sexual preference are wholly irrelevant. So, and given sort of, how we as a society deal with all of that, there's the potential for nothing more than embarrassment and prejudice. So why include it? Certain kinds of health conditions, similarly, may well be irrelevant. If they're relevant, include them, but if they're irrelevant, exclude them, because one, they might distract and confuse the reader and just make the report unnecessarily longer and violate at some level the examinee's privacy. Socially controversial or unacceptable attitudes around things like race and sex roles and religion and politics. Again, I endorse, if they're relevant, they need to be included. If they're irrelevant, why do we include them in the spirit of completeness or something like that? And in some cases, gratuitous quotations that examinees might give us. So why all this irrelevant data in reports? Well, that's how I was taught. That might be a response. This statement, the information was gathered or provided to me, so it should be reported. I think that's a weak explanation, because I don't think any forensic examiners include everything they learned in any report. I think every examiner has to acknowledge there's things that I keep out of the report. Okay, so we agree that we don't include everything in the report. Shouldn't on that list be things that are irrelevant to the referral question? I'm more sympathetic to this third explanation here. If I don't include the irrelevant information, for example, about his medical history or work history, the reader will assume that I failed to inquire about the matter and assume that I conducted a less than comprehensive evaluation. I actually am sympathetic to that, but I think there are some strategies or approaches. My take is when we're conducting the examination, we have wide latitude in terms of what we inquire about. You don't know if someone's educational or medical history is relevant until you ask about it. But once we ask about it and determine it's irrelevant, doesn't necessarily mean it has to go in the report. Nonetheless, I'll provide some strategies for managing that. I think another explanation for why ostensibly irrelevant data are included in reports is the bastardization of an inadequate process. Well, this is a competence to stand trial evaluation, but in reality, the public defender wants an evaluation to facilitate sentencing, but he doesn't have the money for a sentencing evaluation. So the lawyer requested a competence evaluation and is hoping that I put a lot of data in there that might be irrelevant to the competence question, but he can use it in arguing for a lesser sentence. And, maybe the examiner is complicit or not in that. I am sympathetic to the response, well, the law of Texas requires that I include a comprehensive DSM-5 diagnosis. I don't know if that's the case, just making that up as an example. Or my employer requires that we include this kind of information routinely in reports, even when it's clearly irrelevant to the reason we're carrying out the evaluation. I don't want people to violate the law. I don't want them to get fired. I understand why they might do things that they otherwise wouldn't for these kinds of reasons. This, I think, is an interesting concern. If I fail to include information that somehow becomes relevant in the report, somehow becomes relevant, I don't think it's relevant, but someone might argue it is. If I fail to include that, then I could be prohibited from testifying about these data later. So, for example, Federal Rule of Civil Procedure 26A requires that the expert's reports contain a complete statement of all opinions that the witness intends to express and the basis for those opinions. Now, I think that if you keep some data out and some opinions out because you think they're irrelevant, you're in a federal civil proceeding, and somehow a cross-examining lawyer makes it relevant, the opinions you did not include in the report and the supporting data, I suspect the court would be sympathetic to you being allowed to talk about those points. But that might vary from case to case. How to exclude irrelevant data from reports and testimony. First of all, ask yourself, as you're contemplating including in the report, is this potentially relevant? Or am I required by the law to include it? If you're clear that something's irrelevant and need not be discussed, you can cite that, right? Here's some quotes you might include. Only those DSM-5 diagnoses relevant to understanding Ms. Johnson's risk for violent behavior are provided below. There are maybe many more DSM diagnoses that Ms. Johnson has that you're not including here in an attempt to be respectful of her privacy. As a psychologist, meet your ethical obligations not to include irrelevant information. Or something like, my inquiry into and discussion with Mr. Jackson about his medical history indicated that no aspects of his health status are relevant to understanding his ability to parent his children. So I'm not going to talk to you about his chronic conditions and illnesses that really don't need your attention and were not in any way impactful of my opinions about his parenting abilities. Data are included appropriately. I'll start by saying that we should ask ourselves, whenever we're putting opinions in reports, are they expert opinions? That is, are they based on specialized knowledge, training, and experience? I give you an example from a state's evidence code talking about expertise and expert witnesses. And it talks about experts offering opinions that are sufficiently beyond common experience of the trier of fact and would be helpful to the trier of fact as a result. So opinions that aren't beyond the experience or knowledge of the trier of fact really shouldn't be offered by us. So every time we offer meaningful opinions, we should do a check to make sure that it's based on specialized knowledge, training, and experience. Data are included appropriately. For all important opinions, we should provide the factual basis. So if we're going to opine that uncontrolled symptoms of mental disorder leave the examinee at heightened risk for violent acts towards others, we've got to identify the supporting data. What are the uncontrolled symptoms of mental disorder? And where's the support for the relationship between these symptoms of mental disorder and increased risk for violent behavior? If we're going to opine that an examinee meets the diagnostic criteria for schizoaffective disorder, somewhere in the report, you're going to find some kind of listing or discussion of the symptoms that go towards supporting a diagnosis of schizoaffective disorder. I love this quote from Tom Gutile and Paul Applebaum. Telling the truth, the whole truth, and nothing but the truth is the sine qua non of the evaluation. The expert should acquire relevant information, make clear the limitations on the certainty or reliability of their opinion, and acknowledge the legitimacy, when real, of opposing views. All the data, not just the data that support our opinions. Now, I know when we write reports, we don't take an oath. We only do that on the witness stand. But when we do take an oath on the witness stand, it's something like the truth, the whole truth, and nothing but the truth. And I think we should operate similarly when we're writing the report on which our testimony may be well based. Or how about this? I swear to tell the truth, at least the truth that supports my opinions. Might not mention any truth that is inconsistent with my opinions, right? That raises questions about bias and fair and balanced and all of that. We also cite reasonable or likely to be argued opinions that are alternative to ours and talk about why our opinions are nonetheless the right ones. Okay. So, for example, although I believe Mr. Jackson appreciates that he has a mental disorder that would benefit from treatment, I acknowledge that. He appreciates that he's mentally ill and would benefit from treatment. His paranoid belief system that the mental health profession is conspiring to poison him in an effort to silence his political beliefs results in him refusing the very treatments that have the potential to control the symptoms that result in his heightened risk for violence. So I do acknowledge that, all things being equal, that he appreciates he has a mental disorder and would benefit from treatment might go in the category of, don't force treatment on him. I acknowledge that. I'm going to tell you why my opinion is the correct one, that what you'd see later in the report. All data sources are disclosed. All data sources are disclosed. So the reader of the report can form some opinion about the adequacy or the comprehensiveness of the examination and whether something critical is missing. Data, and finally, data and data sources are paired for the reader's consideration. Where did you get that? If you're going to write in the report, the defendant was born in Skokie and grew up in Chicago and made it to the 12th grade, graduated, and then obtained a bachelor's degree at University of Illinois, Chicago, where'd you get that? Is that what he told you? Is that what his mother told you? You see the diploma? Because that can affect, right, the legitimacy, the accuracy of the claim. So imagine, for example, reading a report, which alternatively is written, Mr. Jones told me he developed and sold a technology startup for $11 million, versus a July 2013 copy of Time magazine that Mr. Jones provided to me described how he developed and sold a technology startup for $11 million. I think we all have ladder confidence in the second description. We have more confidence in the second description than we do in the first description. So these are my thoughts about thinking about general principles of report writing. I'm very eager to hear what some of you have commented on or questions you might have, and I think we left at least some time for questions. I will note that if you do end up getting the PowerPoint copy of this lecture, there's a whole bunch of references that follow this. Anthony.
Wonderful. Yes. Thank you so much, Randy, for that thorough overview of some core principles of report writing. And also, as we talk about the lack of jargon, doing so and communicating it in a non-jargony kind of way that's approachable. Somebody that really does walk the walk, so to speak. So we do have in the chat box will be the QR code for those of you that are pursuing APA continuing education credits. Go ahead and open that link, bookmark it if you are pursuing APA CEUs. Here is the QR code above as well, up on the screen that you could use as a shortcut for that. You can enter any questions in the Q&A box. We do have some already that I'll go ahead and throw Dr. Otto's way right now. Somebody noted that They often struggle with considering the relevance of legal or criminal history for a variety of psycholegal questions. Believe that it was included routinely in forensic fellowship in competency and criminal responsibility evaluations. What are your thoughts in general on the relevance of legal or criminal history in
Uh,
the forensic report?
I fully appreciate the concern, and I'm going to say a couple things. One is my general rule is if it's potentially relevant, then it should be included, and you should have a good reason for why it's potentially relevant. So in many criminal forensic evaluations, you can make the argument that it's potentially relevant, depending on the kind of evaluation, for understanding how someone presents around matters of competence to proceed. Is someone with a fair amount of experience in the criminal justice system, or no experience whatsoever? That might help you understand what looks to be knowledge deficits or something like that. I think, candidly, another thing you want to think about is, um, are you compromising the defendant by including it in the report? So, for example, in many competence evaluations, I can't speak for the law of all jurisdictions, but in many matters of criminal competencies, any of that history, at least if you keep it to what have you been convicted of versus tell me about every crime you've committed, what have you been convicted of? None of that is news to the prosecutor. None of that is news to the defense attorney. And none of that is news to the judge if people are doing their job. So you're not, I think the concern is, might this be prejudicial in some way? Also keep in mind that if it's in connection with another kind of criminal evaluation, uh, also keep in mind that typically, if it's a jury trial, jurors don't get the report. Again, there may be some exceptions to that general rule, but jurors don't get the report, so they might not be exposed to the fact that this man 3 times in the past has been convicted of sexual assault, and here he is pleading not guilty by reason of insanity to a charge of sexual assault. Um, if I was, I mean, if that was the case that I was involved in, I'd sure as heck make sure that, although I might have included it for whatever reason in my report, I'd get some direction from the retaining attorney about whether that was off limits when I testify in front of the jury, and it may well be by way of a motion in limine that had been presented by the defense or something like that. So that's my response to that question, Anthony.
With your reference to these considerations of what is relevant to your opinion and at the same time thinking about what could cause harm to the person, somebody had a specific situation where they ask, are there ever situations in which you would not include information from interviewing a family member, even though it contributes to your opinion of their competency, because it could harm the evaluee's primary support system, weighing ethical obligations? For example, if the family member is confirming delusional beliefs the evaluee has that they've been attempting to conceal during the evaluation.
Yeah, I have to say I don't think I would keep that information out with respect to my concern about compromising the person's support system, which I completely get. You know, I'm thinking, before I gathered that information from the informant, I made an effort to make clear the potential complications of talking with me and sharing information with me. I made clear that she would be identified as an informant, although it was unclear at the time that I approached her whether I would include anything she ultimately agreed to present to me. And the phrase slippery slope sort of came into my head as you were laying out the question, Anthony, because it suggests a slippery slope to me. When I start saying, well, I'm not going to provide some information that was relevant to my opinion because of the long-term impact it might have on relationships or something like that, What I did try to make the point was I will include information if it's not relevant to my opinion. So, for example, the example I often use with trainees is if in a competence evaluation, the defendant refers to the judge using a racially derogatory term. You can make some up for yourself. I'm not going to make reference to that. I mean, I know judges make great efforts to be independent and objective and not let things affect their decision making, but the judge doesn't need to know, in most cases, that the defendant referred to him or her using some racially pejorative or hurtful term. Why even put it up there? Again, if there was language used that I think is relevant to the defendant's competence, I'm gonna swallow and include it. But I do try to be respectful of defendant's privacy, which I think is really about, in part, being respectful towards them as people, and being appreciative of the circumstance they're in that gets them into involvement in a legal proceeding where some aspect of their emotional, behavioral, cognitive functioning is in dispute.
I think this question here was posted at the time that you were discussing documenting all the efforts you've done, including if you were trying to gather a particular piece of relevant data and ultimately were not able to acquire it or you did not get a response. Somebody asked about what about when you're given, say, a highly redacted data, such as child protective reports that are so redacted you can't even make sense of who's being referred to the document. So essentially, you get data, but it ends up being in a condition that you can't use. How do you communicate this?
Good question. I've never had that experience, but I imagine you could, for sure. Lay it out. Although documents were purportedly summarizing the examinee's history involvement with Department of Social Services as a child, the overwhelming majority of them were so heavily redacted that it was difficult to uh, get any meaning out of them. So you made an effort. I think you get credit for reading the document or obtaining the document if they weren't provided for you. But you want to acknowledge that there's the potential for them to be helpful. Why else did you read them? But in reality, no, they weren't helpful. And again, I think you want to affirmatively disclose that upfront, because who knows, maybe an attorney gets that report and then makes an effort to get a lesser redacted copy to you, right? Maybe that happens. But again, I think you're better off affirmatively disclosing that than not disclosing it. And someone saying, well, Dr. Otto, I see here in your report either that you never mentioned any Department of Social Service records, because I think it'd be stupid to be provided the records and not make mention of them as a potential data source. Or you just list them as a data source and you don't point out that the reason you're not referencing them in your report is because they're not usable. It doesn't have to be redaction. It could be photo. Everyone has received photocopies of records where it's so light or the writing is so illegible that you can't make hide nor hair of what what the content is. Give
Certainly.
yourself credit.
Um, I'm being aware of the time. We'll wrap up with one or two questions here. Somebody in response to, I think your derogatory statements about the judge scenario, they asked in a competency examination, would you include if they made derogatory statements, not the actual words, about their defense attorney? I guess since it might relate to their ability to work with their attorney.
Now you're making it relevant. Great point. My attorney is a no good whatever. I don't know, either a no good Republican or a no good member of a racial class. That can be really helpful with respect to mulling over the issue of capacity to consult with counsel. Now, if it's my attorney is a no good misogynistic term, racist term, this might really give you some insight into whether he's incapable of working with counsel because of a mental disorder, or simply unwilling to work with counsel because he harbors racist attitudes or sexist attitudes or misogynistic attitudes. Make the derogatory comment relevant, and then all of a sudden, my take on it completely switches.
Final question that somebody asked about if you discover inaccuracies in your report, can you revise the report even after it was submitted to all parties? And I guess I will add, like, when would you consider communicating and how would you consider communicating if after the fact you've discovered inaccuracies in your report?
I'm not aware of any ethical prohibitions against making accountings of work more accurate. And I could probably search for and find some ethical thought that it is the right thing to do. But I think, as in so much forensic work, transparency is critical, that you do it in a way that others can know about it. So it could be a memorandum. You get a phone call from an attorney. Dr. Otto, I got your report. I'm very happy with, the substance and focus of it, but I am a little disappointed in the fact that there are a number of factual errors that I don't think in any way affect your opinions, and I don't think are prejudicial to my client. But nonetheless, I don't feel good about that, and I'd like you to correct them. Sure, I can write a memorandum. I'll go through the report and I'll look for my own factual errors. You can give me a list of the factual errors, and I'm happy to uh, reference those errors in a memorandum that I'll submit to you, and I assume you will send on to opposing counsel or attach as an appendix to the back of the report. Or maybe you want to actually alter the body of the report, just making clear that it's an altered report. It reflects feedback regarding your inaccuracies. Obviously, no one in this training is going to say, "Oh," and when they suggest that you need to change opinions, no, we're not going to change opinions. I mean, I guess unless the facts that were inaccurate, cause you to change your opinions. Well, he was. I was assuming he had no history of violent offenses, and I got that wrong somehow. He's got all these violent offenses, so my opinion about his risk is heightened. Again, if that's the case, I think you can make the change. Just be transparent, so that everyone knows you made errors and you made an effort to correct them.
Dr. Otto, Randy, thank you so much for going over these core principles. A report can only be as impactful as it is understandable. So we very much appreciate you sharing all of these considerations and practical points and thinking about how to make effective communication to court parties. It is much appreciated.
My
And
pleasure.
and that wraps up this week's Law and Mental Health series. Next week, we have Doctors Lisa Kahn, Crystalline Tussey, and Beth Arredondo, who will be discussing issues of aging and cognition relevant to forensic evaluation. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time.